do actually think it ought to be covered, but I understand you got to look at it all the way. But I told him, for PR purposes, I'm willing to drop it.
Can I hear? Oh, yeah. Double click gets it off. Okay. What part of okay don't y'all understand? All right, we're going to start. Just to like to welcome everyone. We'll start this meeting like we do each and every meeting. If you'll please bow with me. Gracious Heavenly Father, for another day in your kingdom, we're eternally grateful for all the many of us corporately and individually. We say thank you. Lead, guide, and direct us in all that we do. Please let us show character, wisdom, and compassion. I ask these things in your Son's name. Amen. Welcome to the first meeting of the Rules Committee. I would like to take this time to recognize two new members of the committee. To my right, Representative Barbara Sims, and to my left, Representative Alan Peake. You're welcome here. Please get a little folder that tells you what the rules are. If you miss two, adios. There you go. You can have there are plenty of excused absences, and I'm not as tough as I sound. Okay, the normal procedure, they're already on the wall. Mr. Maxwell, Chairman of the of the Retirement Committee. You're the insurance. Wait a second. Richard.
No, testing. There we go. Thank you, Mr. Chairman and members of the committee. We just want to tell you that your House Retirement Committee has been working effectively and efficiently getting bills moved through. So we're proud to be here to have the first ones to come before you. I got two propositions today. House Bill 295. This is a problem that we realized we had after 2009 when we set up the GSEPs, the new employee retirement system for employees hired after 10, I believe it was. We had a transfer procedure in place under the existing ERS retirement system that allowed employees to move between TRS and ERS and transfer credit. Because of the formula that we have in the new GSEPs program, that procedure wouldn't work for this. So we have looked at it and got a bill, we believe, in place that would allow employees to transfer time between TRS and ERS without detriment to the employee or to the systems. So what we're asking is your favorable consideration to allow this bill to go forward. We do have a lot of people that do transfer before vesting. After vesting 10 years, it's not a problem, but these are people that are between 1 and 9 years. No.
Yes, sir. Turn the rules off. Next. Next one over. Turn it the other way, I think it is.
Yeah, try it like that. How about that? Okay, I don't know what desk I'm at. Okay, the question is, are there any questions for Mr. Maxwell? That's it, Mr. Maxwell, next one. Now, okay, wait a second, I do have one. Ms. Dempsey, your button is pushed.
Is your new member?
Mr. Chairman, I'll just make sure my...
That's one unexcused absence. Cheddars for everybody. Okay, Mr. Maxwell.
Yes, sir. The next bill is House Bill 351. And what we're asking here, this bill changes a tiered bond forfeiture fee system to a single amount, $3 for each criminal and quasi-criminal case for violation of statute of traffic laws. This goes to the probate court's retirement fund. We did have a tiered system, and we're asking that we change it all to a flat $3 fee. That'll help their funding a little bit in their retirement fund. The ACCG, none of the people have a problem with this. They think it's pretty good. It'll actually be a little less paperwork for them to have to keep up with the tiered system on charging $1, $1.50, or $2.50 for these fines, just flat $3, and we'll go forward with it. So we'd ask your favorable consideration on that.
Again, I would ask any questions. Thank you, Mr. Maxwell.
Thank you, Mr. Chairman and members of the committee, and I ask for your favorable support.
Mr. Nix.
Thank you, Mr. Chairman. And by the way, I could hear you when your mic was not on, because when you speak, I listen very, very closely.
They ain't going to help you much.
I'd like to ask for House Bill 713 under the modified open rule last bill. This bill is really to make some minor changes in House Bill 186 that we passed last year related to the career and college readiness initiatives. The Department of Education asked that we delay 1 year the implementation on some of their initiatives. We felt like this was a good idea because of the things they've got going on with Race to the Top and Common Core standards. So that would be delayed from 2013 to the year 2014. The second provision that it would do, it will add under Section 2 to allow them to have a minimum course of study and career education for students in grades K through 12. They felt like that was good to begin to prepare the students for that. And finally, the third change would be that we would change the statewide common assessment from the 10th grade to the 11th grade. And we felt like those were reasonable changes to be made on a bill that had a very aggressive schedule for implementation.
Are there any questions? Thank you.
Thank you.
Mr. Willard, I'm sorry, Mike, you have to get behind the chair.
Thank you, Mr. Chairman. I bring before you House Bill 683, which deals with the garnishment law. Since the beginning of garnishment in Georgia, all corporations or business entities have had the ability to file what is a response to a summons of garnishment. This past September, however, a committee of the State Bar issued an opinion finding that the filing of this answer or response by a garnishee constituted a form of practice of law, and corporations are restricted in what we call courts of record, which are the superior courts and state courts, from filing on their own behalf the answer in garnishment. To digress for a moment, we do have and have had for a number of years an exemption which addresses what we call magistrate type proceedings, which is where a lot of the garnishment actions are taken anyway, which is below $15,000. And the corporations have had, by statute and state rule, the ability to file their responses to the garnishment. The opinion of the State Bar Committee went up to the Supreme Court, was affirmed, but as a part of that affirming, Justice Namias wrote a concurring opinion, which I'll read a portion of it to you. So I am sure that a rule change would be sufficient. A statute similar to OC, this is speaking of how they could change this, A statute similar to OCGA 18-4-61, which underlies Rule 15.1, may be required. That Rule 15.1 is the one I was speaking of, dealing with the magistrate courts as an exemption. Justice Namias goes on to say, but the State Bar and the business and business associations that submitted briefs raising these concerns should understand that today's decision leaves them free to seek such a remedy from the Judicial Council or the General Assembly. Word came back to me shortly after this opinion that the Judicial Council did not have the desire to work with it or find a solution, so they were really leaving it up to the General Assembly. This rule change or opinion has put a great deal of strain and cost on our business communities because of garnishments that are filed routinely against banks, especially, and against corporations. Say since the beginning of time, these entities have been able and have done their own answers as far as response. What we're doing in the law is recognizing that a response to a garnishment is not really in the same sense as a legal proceeding when we think of having plaintiff and defendants, that you're not dealing with someone who is being brought into court because of alleged wrongdoings. You're really seeking to have the garnishee just report to the court, do you or do you not have any money or properties that may belong to the defendant against whom a judgment has already been rendered. So with that in mind, we have gone through what is the garnishment law under Title 18, Section 4, and recognize that the fact that a garnishee is asked by the court, under direction by the court, to file an answer, it is not in the true sense an answer as a pleading. It is a response to a directive of the court to inform the court what do you have as far as money or properties. And that's why one reason the bill is somewhat lengthy is because we went through the entire code dealing with this and made the supportive changes to that provision. This also applies not only to corporations, but to even the state governments, county governments, and city governments, because there again, these entities would not be able to do what has been done in the past, for instance, our General Assembly. We have people from time to time working for the General Assembly against whom a garnishment, a judgment is issued, and therefore a filing of a garnishment may occur. And we've had routinely the ability to file the response to that, but with this change of law, we, as well as everyone else as a corporate type entity, would be under an obligation to go out and hire an attorney for the purpose of making this report to the court. So we're modifying that provision of the law. A second thing we're doing is recognizing, because there's been a lot of confusion, if you look on page 3, Section 6 deals with the method of service. We've had some fairly loose language under the garnishment law dealing with how and to whom service is made of a garnishment. And because of this looseness, from time to time, people might walk into a bank, serve the garnishment on the bank teller or a secretary sitting there, believing they're making good service. And that was always an argument because of the wording we had here. So what we have done is we have recognized that the appropriate method of service will be as provided in Code Section 9-11-4. It is that code section that deals with all forms of service, whether it be on individuals, businesses, corporations, and the like. So, Mr. Chairman, those are the major changes. We also, one last change I'll mention is when a garnishee files their response, there is ability for them to help cover their costs, and the amount statutorily was up to $50. That has been increased because that law has not been changed for over 30 years, and it was increased to $100. That covers the major changes in the law, Mr. Chairman. If there are any questions, I'll be glad to take them.
Yeah, we've got a couple of questions. Mr. Whip.
Yes. Thank you, Mr. Chairman, for bringing this important bill. The bottom line is that this bill saves businesses money because a business should not have to hire an attorney when they're not an adversarial party to an action and simply perform a purely administrative task.
That's correct. And they have all now had to, in fact, go out, employ attorneys. Most of them, even though they may have inside counsel, do not allow their inside counsel to, quote, practice law even for their corporation.
Minority Leader.
Thank you, Mr. Chairman. Chairman Willard, I have a few questions. Is it not true that this will, while I understand the intent of the changes, does it not create a double standard where the garnishee, the corporation or the bank, will no longer have to have an attorney evaluate the legitimacy of the garnishment, but an individual who wants to challenge it will still have to have an attorney?
Well, if you're a garnishee and you file your answer to the garnishment, and then the plaintiff or the defendant files a traverse, which is being a challenge to that garnishment, then the circumstances change. You are now going into an adversarial situation, and the law addresses that by saying, under those circumstances, then there will be a need to have an attorney on behalf of the business corporation or otherwise to argue on behalf of the corporation against that traverse.
The second question I have, thank you. My concern is that while it is true that some garnishments are fairly routine, there are specific federal laws that preclude garnishment of Social Security benefits, for example, and this would remove the responsibility of the bank or the employer, and I'm less concerned about a bank and more about an employer that may not have the requisite knowledge to know that when they turn over or they agree to the garnishment, that they are garnishing wages or protected monies that are not allowed to be garnished under federal law?
Good question. And I'll say in most cases, the lawyer is not aware of that either. The lawyer who's filing, if they were a lawyer filing on behalf of the bank, for instance, there is not a going in by that lawyer and exploring to see what the source of the funds were. They rely on the clerical information they get from the bank. And that's where a challenge may have to come by the defendant saying, wait a minute, all I have in that account is my Social Security monies, and that'll be something for the court to make the decision. But it's not going to change what may or may not come about as a challenge to that type of question of whose money it was, where it came from.
And one final question. So let's presume that the garnishee moves forward, absent having legal counsel that advises that it's unlawfully garnishing. Is it not true that the employer or the bank, the garnishee, is now responsible and will be held liable for the entire debt that was illegally garnished?
I couldn't follow your question. Could you speak a little closer to the mic?
Certainly. Let's assume that the garnishee is a bank, and the bank unlawfully garnishes Social Security wages.
A lawful garnishment is filed.
A lawful garnishment is filed. The garnishee files, essentially says, yes, here's the amount of money in the bank.
Right.
It includes Social Security benefits, which by federal law are protected from garnishment. If in the event the person being garnished is successful in challenging that garnishment, is it not true that now the garnishee, the bank, is liable for the debt that was garnished?
I don't think they are, no. That's the purpose for the traverse. Either the plaintiff or a defendant can challenge the response made by the garnishee, but it's going to be up to the court to finally make the decision whether or not this monies that were paid in would or would not be subject to a garnishment. So I don't think it's going to expose the garnishee to any greater liability than would otherwise exist.
Thank you.
Thank you.
Thank you, Mr. Chairman.
Ask for your favorable support.
I would remind everybody else that brevity really means a lot to me. The leader just said he was brief. Okay. Mr. Dudgeon, I'm going to get a gong like Bill Lee used to carry.
Thank you, Mr. Chairman, members of the committee. I bring to you two bills today, House Bill 705 and 706. Both of them are a result of the work of the Education Finance Study Committee, which the legislature created last year. The committee had 20 members from the education community and the legislature meeting on basically reforming and modernizing our financial formulas and so forth around education. But another part of their mission was to look at Title 20 and to look at other areas of the education code that needed some work. So we'll start with House Bill 705. House Bill 705 addresses the 65% rule. If you recall, that 65% rule passed the General Assembly in 2006, which said that 65% of of expenditures in the local system had to be made for direct classroom instruction. And I think everybody is 100% on board with that goal. But what happened was Department of Ed and the local systems looked at the data over the past several years and found there's actually no correlation between who's doing 65% and who is doing well in the classroom. And when the commission looked at it, they made a recommendation just to repeal the entire section on 65%. But in discussions with some legislators here and so forth, the bill we're actually bringing forward today does not repeal the section. It adds some areas to the definition of 65%. So if you look at the bill, we're clarifying that technology in the classroom is okay. That was sort of implied. We wanted to include it. And then we're also adding in costs for transportation, media center people, and guidance counselors into the 65% formula. And the DOE estimates this will bring a lot more systems into compliant doing this. So that is my first bill, and I'd like to take questions now, if there are any.
Like for you too. There's no questions. Next bill.
All righty. House Bill 706 is what we call the Title 20 repeal bill. We're not repealing all of Title 20, but basically what we did is we opened up to the education community and everyone the idea of what parts of Title 20 are bureaucratic, unnecessary, unneeded, and could really go away or needed to be modernized. And we have 39 different sections in this bill. It's very complicated, but to give you an overview of the things we're dealing with. Number one, I want to say we're not taking away any programs that are currently funded. There are several programs in here that have been on the book from the 80s and 90s that haven't been funded in years. We're going in and taking those off of the books. And let me go over some of the other specific things. We're allowing the state board to meet in other places in Atlanta. We're undoing some of what they call the Linda Shrinko laws, where they passed some laws sort of changing around and limiting the authority of the superintendent during that era, and we're going back to what we would call a normal governance. We're getting the state DOE out of the education TV business. That's another 1980s era thing. Doesn't affect what Atlanta does with PBS. Changing up some other language around from the 1920s around school superintendents, language around kids moving around the country, several mandates on how school systems should do summer programs. We're still going to have summer programs, it's not mandating it here. Some bureaucratic paperwork things we're getting rid of. We're getting rid of a state-created middle school program that's not funded, but there's federal programs that do very similar things. We're getting rid of a 1919 requirement to do a census of the school system. We do QB and FT counts now that's much more modern than that. We have a 1959 law, exactly how principals should be bonded. We're getting rid of that. There's an Education Partnership Act from 1990, which has been replaced by local school councils. And one of the more marquee things in here, and how I actually got interested in this subject, was the last section's repealing. Right now, the law in the book says that a student cannot use an electronics communication device in the classroom. And as we know, more and more systems are using bring your own technology and bringing their own iPhones or iPads or whatever devices to the classroom, and the teacher has a lesson done over the internet. And technically that's illegal except for the systems right now who have IE squared or charter. So we are pulling that off the books as well. I want to make a point about these bills, especially this one. This is the consensus list. Started off a lot longer with this. This list has broad consensus of school boards, school superintendents, PTA, teachers associations. So this list we're bringing you already has been through 5 or 6 different hearings in the education community and through the education committee, so it's been well vetted. And I would yield for questions.
The minority leader.
Thank you, Mr. Chairman. Representative, can you look on page 2, lines 43 through 45?
Yes.
Now, I understand the intent of lines 39 through 42, which essentially permit meetings to take place wherever designated. But
That's
can you
right.
speak to the necessity to remove what seems to be standard language that you find in parliamentary procedure, saying that actions have to be taken at, I understand that actions have to be taken at a regularly called meeting.
My understanding from the council for this section was she thought it was a derivative of the requirement to remove the Atlanta requirement. Meant that this part of language was sort of a secondary thing that was necessary to make the code consistent, because if it said that the only enforced unless the meeting is taken in the state board at the state capitol. So I guess what you're suggesting, Madam Leader, is that only the state capitol should be taken out of that and the rest of that should be in there?
Correct. I just don't understand why you'd strike the entirety of that section because that removes a certain requirement.
Other than the council drafted up this way, and we know the intent is to allow them to meet other places in Atlanta, I don't know, and I don't have an objection to that. So.
Thank you.
Any other questions? Thank you.
Thank you. I ask for your favorable consideration. Thank you.
Mr. Weldon. Mr. Weldon?
Yes. Yes, Mr. Chairman.
Members, I forgot to say it. If members have bills, you can stay in your seat. I'm sorry, Wendell. Forgot about it. But you can go from there if you would like.
Thank you, Mr. Chairman. I'm here asking for favorable consideration on House Bill 424. This bill provides that the death benefit that's issued to Superior Court clerks who are either active or retired, they'll get the $5,000 benefit. Either way, the way the bill was previously written, it said that any the $5,000 benefit was only paid if they were an active clerk and they died in service. And this just modifies it. This is a fiscal bill. This will be absorbed by the fees and costs that are collected by the clerks, and it'll be about a $70,227 charge up front. And the auditors have said this is something we can easily absorb in the fund because it's well funded. There are no questions.
There are. He has a physical note.
Yes.
And again, it was 70,000.
Yes, Mr. Chairman.
That's based on an assumption, correct?
That's on the actuarial study that was done by the state auditor, and 70,223. And it says in the fiscal note that according to the actuary, the first year cost is $70,223. However, the required employer contribution would not need to increase because the fund is in a well-funded position, and currently the amount of revenue generated from fines, fees, and bond forfeitures is sufficient to cover the additional costs associated with this bill and to ensure the fund maintains funding in accordance with the state minimum funding standards.
So that means that 14.18% people have to die, I think. Thank you, Mr. Roberts.
Well, actually, I was just going to wait till he come back. But the only question is, currently, if they serve one term, do they go into the retirement system? I mean, I'm not quite sure. Do they have to be in the retirement system if they're out of office in order to get it? That's what I'm...
If they're active or retired,
okay,
they would get the death benefit.
Anything else? Thank you.
Thank you, Mr. Chairman. I ask for your favorable consideration.
Members that have bills that would like to present them, just hit your button. Okay. Ms. Cooper.
Okay. Thank you, Mr. Chairman, members of the committee. I bring House Bill 675. This bill corrects an unintended consequence from a bill that was passed in 2009, but was not discovered until this summer after we had already adjourned. The Senate Higher Education Committee got very specific about the accreditation of schools of nursing, and it omitted a way for diploma programs, or the 3-year schools of nursing, to meet the state requirements, and also for the military trained nurses, because they do not seek regional accreditation. So the bill corrects those problems. We have about 125 nurses waiting to get their license, and this bill does nothing but correct that problem.
Any questions? Okay. Mr. Green.
Thank you, Mr. Chairman. Members of the committee, I bring you House Bill 337. It is out of the retirement system. It's brought on behalf of the Georgia Sheriff's Association, and it's the Sheriff's Retirement Fund. And it's a bill that allows a member of the Sheriff's Fund who elected spousal benefits at retirement to revoke the spousal benefit election in the event of a divorce. And if that takes place, if it's revoked, the member's monthly benefit will pop up. And we have those pop-up provisions already with our ERS, TRS, firefighters, probate judges, superior court clerks, and so on. And that's what it does, Mr. Chairman and members of the committee.
Yeah. The Minority Leader.
Thank you, Mr. Chairman. I spoke with Mr. Green about this earlier, and we'll ask him the question again. My concern is whether or not this provision creates a conflict of laws if a divorce decree includes the provision of these benefits in the divorce decree to the divorced spouse. So, for example, if a deputy divorces his wife and as part of the decree, there are certain benefits that are included in that divorce decree. Will this somehow interfere with that or unsettle that decree? And he wasn't able to provide a response.
Mr. Green.
Thank you, Mr. Chairman. I did speak with a lady, and I told her I could not answer that question. Undoubtedly, we have had this pop-up provision for some time with these other pension funds, and I don't know how we have handled it in the past there.
Mr. Willard.
I'm going to defer to Mr. Weldon. If I can, we both talked about this issue.
Mr. Weldon.
Thank you, Mr. Chairman. Thank you, Mr. Willard. If I could pose a question to Mr. Green, isn't it true, Mr. Green, that the divorce decree is independent of this election by a member of the sheriff's retirement system, and they're not directly related, and this would not, as a matter of law, affect the divorce decree? Isn't that true?
I have just been, Mr. Chairman, I have just been informed by some older members on the retirement system that is true, that have been on there a long time, and they said that's true. And I expect Chairman Benton could explain it a little bit more.
Mr. Benton's button's not pushed, so there won't be any explanation. Okay. Anybody else? Okay. We'll set it. Okay. HB 295. Do I hear a motion? Any opposition? Hearing none, we'll set that. It'll be open. HB 424. Do I hear a move? Any opposition? We'll do it open. HB 713. Do I hear any opposition? It'll be on under modified open. HB 683. Do I hear a move? Any opposition? All those in favor signify by raising your hand. All those opposed. Wait a minute. We're going to do 683, modified structure. You've already moved, we voted, it's good. Tomorrow will be a little busy, but that's a start. Well, and he called in and just said she said he just could not get here.
I'm going to take this form and redo it and put the numbers where they're sitting.
Yes, ma'am.
No.
You're right.